From closet baby to closet Cozzy? Nice blue sheet. Uncle Grandpa finally filed his response to Turtleboy's motion to recuse him as special probiotic just 2 hours before today's scheduled hearing. This and more in today's video.
If I live to see another motion after your decision on the motion to disqualify, the next logical motion to take up would be the defendant's.
Hello, and welcome back, roommates, to another titillating edition of Alexasrewm, where we are not lawyers, we are not medical professionals, we are not law enforcement, we are just people who have opinions about all things going on in the true crime community, including a guy who looks like he's about to deliver the 7-day forecast from his dining room, Robert Cosgrove. Anybody else think that he's got Ken Mello hiding behind that thing? Who apparently woke up and decided today, just 2 hours before this hearing was supposed to take place, that he was finally going to file his response. Right on cue. 2 hours before our hearing, Robert Cosgrove finally files a response to our motion to recuse him as special prosecutor. It was due on November 17th. And I'm just reading it now. Now, to be fair, for a while there, I was genuinely convinced that this man had croaked in Ken Mello's lazy boy chair whilst clipping coupons. So last week, if you recall, Uncle Grandpa finally emerged from hibernation after going all 48 hours and then some and then some. No, don't call. Or, hey, my inbox is so full because I'm old and I don't know how to delete emails from my email box. I don't know why he's Irish and has jazz hands. But he did, however, find the time or the space in his inbox to respond back to one Ted Daniel, which we went over in my last video. And what do you know, lo and behold, a few hours later, Cosgrove finally files his opposition to Bettero's motion to dismiss/qualify, etc., etc. And because he filed his opposition to their motion to dismiss 8 days late and dropped it on the judge's lap right before Thanksgiving break, the judge was like, hey, I don't have time to look through all of this, so I'm going to change this hearing, which was supposed to be the motion to dismiss hearing originally, and we're just going to make it a status update hearing. Which brings us to today's hearing, which took place over Zoom, featuring Cosgrove's bedsheet. Broken Baker streamed it just to serve TV. The only thing that really came about it, in my opinion, that I felt like was somewhat significant was the fact, aside from Cosgrove's travel plan, was a potential trial date. So it looks like they're aiming for sometime late November, December, which is interesting because that just so happens to be after the Norfolk County DA elections are set to take. I think Adam Deitch is watching, but I will link the stream that Broken Baker did in my show notes below. Bettero obviously hasn't had time to sharpen his pencils yet, right? He's gonna need some time to respond to this. It seems like we can expect his clampback sometime within the next 10 business days, so we'll be on the lookout for the motion to disqualify hearing has been now shoved all the way to January 23rd, so the wheels of justice are turning, inching forward like a constipated sloth. And the judge also told them, hey, no more replies after January 13th, unless something new and spicy reveals itself. So hopefully he sticks to his word. So anyways, now let's go through Cosgrove's response to Bettero's affidavit in support of, quote, motions. Because this thing is wild, y'all. It is wild. The defendant, Aiden Carney. Oh, and shout out to Kyle Sharkey on the Twitter X's. I believe they were the ones that I swiped this from. So thanks to you for providing. And I'm gonna jump around a little bit because there's a lot of background that we've already covered in previous videos. So I have a whole playlist dedicated to all things Turtleboy. You can check it out. I'll link it in this video so you can catch up to speed if you have no idea what I'm talking about. But for those of you who do, the defendant, Aiden Carney, has filed an affidavit in support of motions from attorney Mark A. Bettero. As with a previous Bettero affidavit, henceforth BA, the motions are phantoms and there is no memorandum of law accompanying the non-existent motions. The Commonwealth infers that the affidavit in support is intended to serve all three functions, and assuming, arguendo, that this court consents to accept it as such, the Commonwealth offers the following response. The defendant asks this court to disqualify Special Prosecutor Cosgrove from docket number yada yada, the 2023 case, which is the Lindsey Gaetani case, because of his alleged irreconcilable conflict with Miss Gaetani. Much has been said in previous filings with respect to Miss Gaetani, and she herself, with prior leave of this court, has filed a number of pro se documents, and I believe Grant Smith Ellis has posted those up on his Twitter X's like a while ago. So if you want to read that, I think it's like 80 pages or something like that. Crazy. All of that pays examination, but the Commonwealth offers a brief background summary. Gaetani is a single mother and a faithful, perhaps even compulsive follower of online postings on such outlets as YouTube, why it should be capitalized, X, and Facebook. You could just say online post. I feel like Gen X is probably the healthiest generation when it comes to social media, but like millennials, Gen Z, and boomers, highly addicted. It's fair to say we're all kind of compulsive followers of online postings and YouTube presentations and such. In this context, she viewed some of the defendants' online postings related to the then Karen Read case, sent him a laudatory message, and ordered one of his free Karen Read t-shirts, then sent him a photo of herself wearing that shirt. So they get together after going back and forth over, I think, like text or Facebook Messenger, and start hooking up, right? And when that took a nosedive, Lindsey switched teams. Whether on her own initiative or as the defendant posits, the influence of other denizens of the online community, such as Catherine Peters. Is it Peters or Peter? I always thought it was Peter. Gaetani contacted Teletal, who was leading the NDA investigation. So, not the Norfolk District Attorney's offices investigate, just Meatball's investigation. Interesting. Into intimidation of witnesses in the Read case by the defendant. Teletully interviewed Gaetani. The Commonwealth had already developed another witness, Natalie. I'm just not that German to read. Natalie was the go-between Turtleboy and Karen Read when he first started covering this case. And then Karen Read, after a while, got tired of talking to Natalie, and she binned her off, and Aidan Carney and Karen Read started communicating more directly to help him develop his story, which again is not a crime. If it was, a grand jury would have indicted them on conspiracy charges, and they didn't. So there's that. And she could attest to communications between Karen Read and the defendant during the months of April and June 2023. Also of note, Teletully didn't just interview Natalie, he flew first class to California to interview Natalie. When there's this thing in 2023, you can't even say, oh, this was before Zoom and FaceTime and all that, and Skype and Google. You can even use Google too if you don't want to pay for Zoom. They got the free options too. You can do that. You can get a 45-minute interview for free on the Zoom free plan. And you can record it, right? You don't have to actually physically interview somebody in person unless they're like a mass unaliver that we don't know about. You could have interviewed her over Zoom or over the telephone. And Gaetani's information confirmed such contacts after that date based on what the defendant had told her. So Lindsey was interviewed after Natalie. And this was all during Ken Mello's time special prosecting this case before he was like, oh, I'm ill and I cannot special prosect anymore, even though he's the keeper of everything, which has been a lot of the reason why discovery issues continue to issue. So in the course of litigating a Dedham District Court case involving alleged violation of the 209A order granted Gaetani against the defendant, Cosgrove had provided a discovery the Medfield police report on the October 14, 2023 incident to Attorney Bradel. So this is where Lindsey accused Aiden Carney of essaying her. And then because this report was shared in a public filing, it was written about, published by Jason Broyles at Not Haley Walbrecht on the Twitter X's in a series that he had put together. And because of this, Lindsey got pissed and was like, yo, you can't share the information in an essay report, and I'm going to sue you. That's essentially why we're here today, and how she has now since reversed Uno'd back to the side of justice to an extent. So the factual basis of all our allegations against Cosgrove is that his turning over the report to the defense violated yada yada. And as a result, Gaetani's filing ANC, Cosgrove filed a motion to withdraw from yada yada, which we saw in many hearings past, which you can catch in my playlist, where he was like, yeah, there is a conflict because she's suing me and I can't use her as a witness and say she's credible, but at the same time be like, whoa, 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 she's a liar because she's suing me. So quite the conundrum there, and prosecuting an indictment where she was the alleged victim and primary witness. That motion was allowed without argument and without objection. That's the 2023 case. Now we're talking about the 2024 case. There's a lot to keep track of here. But now the defense seeks to leverage that withdrawal to force Cosgrove's removal from the present case, in which Gaetani is not alleged to be the victim and is not a necessary witness for the Commonwealth. Natalie, girl, it's your time to shine, is what they are saying. All of the named victims in the present case are either witnesses in the Karen Read case or relatives of witnesses. Gaetani is not a precipient witness with respect to any of the counts in the present case. Well, then, if Natalie was enough and all of the other witnesses were enough, why did you wait to arrest Turtleboy until after Lindsey Gaetani became a character in this soap opera that you've created? To the extent she would be of any use to the Commonwealth at all on these counts, it would be to testify based on her conversations with Carney as to Carney's relationship with Karen Read, which goes to his motive for the intimidation of witnesses. Gaetani would be expected to testify that during her relationship with Carney, Karen Read would come up a lot in conversation. Which again, I mean, it was Karen Read was the topic of a lot of people's conversation, right? Like, are we all intimidating witnesses here? Further, that he told her he communicated with her on a daily basis. A lot of people do communicate with Karen Read. That with much of his reporting on the Read case, he would have to run everything by her. That she had a lot of control, or almost complete control, over anything that he posted. He was not allowed to make any sort of comment about her case without first consulting with her and getting her prior approval. If the Commonwealth wishes to introduce such information, it can do so through other means, including the contents of 2 of Carney's cell phones seized pursuant to warrant. More taint. Everybody's tainting. Which show extensive communication between the defendant and Read, as well as communications with some of Read's attorneys. In short, there is no need whatsoever for the Commonwealth to call Gaetani, and no need for prosecution to, as the defense posits, defend the credibility of a prosecution witness who has sued him for his alleged misconduct. I mean, they literally used and abused her. And I know a lot of people have feelings about Lindsey, and I have certainly shared my thoughts and feelings about what she did to Aiden Carney in my previous videos. So I'm not going to be like, yeah, go girl, girl power and everything. But what they did to her was ducked up 100%, 110%. And regardless of how we all feel about what she did and her as a person. Two things can be true at the same time. She could have done something really horrible, but then also have been manipulated and used for other individuals who helped cover up an unaliving of a Boston police officer, because let's not forget that, and weaponize the justice system because they don't like what this journalist has to say about them. And it's absolutely appalling and disgusting, and a disgusting use or misuse of taxpayer money. So, the defendant argues, however, that it will call Gaetani, who has apparently now, for whatever reason, made a complete U-turn and taken a Carney-like position that Special Prosecutor Mello and Teletully conspired with Kate Peters, so now she's Kate Peter, before she was Catherine Peters, to use her and sacrifice her as a pawn to take down Carney, and that therefore Cosgrove should be disqualified on the ostensible grounds that he is somehow ethically conflicted from cross-examining her. So does that then mean Kate Peter is your new star witness? Because it was Lindsey, but now it's Kate Peter, right? And there's some stuff that dropped the other day that Lindsey shared about an email that she had sent. I think this was in the recent discovery dump that Turtleboy's team had gotten. That's crazy. So, whatever purchase this argument may have for the now dismissed complaints where Gaetani was herself the alleged victim, there is no basis for dragging the entirety of that dispute into the present indictment, where Gaetani accounts for virtually zero of the Commonwealth's evidence, either in its collection or its presentation. So, what's also really ducked up too is like, you were the guy who was going to prosecute her case on her behalf as the victim, right? She was saying, Turtleboy essayed me, and you were the guy who was leading the charge on that case. And she sued you, and now you're like, well, now she's just an alleged victim. She's just making it. We don't need you anymore. Bye. See ya. Like, for real essay victims, like, what kind of message does that send to them? Or to anybody who comes forward and wants to file a report. The expected evidence will primarily be the testimony of the alleged victims and Carney's own video online statements. A side trip into whether the Commonwealth did or did not properly conduct the Gaetani investigation is irrelevant, not probative, and highly prejudicial, threatening to turn the trial into a circus. You turned it into a circus. Nobody else turned it into a circus. And I don't even just mean Cosgrove. I mean everybody, the entire Norfolk DA's office, the McAlberts or House defendants. And the only reason why we're here is because of you using. And again, I'm not saying Cosgrove used her. He just stepped in after the fact. But he ain't no saint. Just a patron saint of procrastination and prostate. The reason why we're here is because you used Lindsey to help support this false narrative that Aidan Carney has been conspiring with Karen Reed to intimidate witnesses. The Commonwealth will vigorously oppose the attempt to divert the jury down this lengthy and winding side road to nowhere but confusion. I think the only one who's confused is you. Did you take your pills this morning, sweetie? Should this court, after hearing, permit the proposed Gaetani defense testimony to the extent that Miss Gaetani's U-turn contradicts previous statements made under oath, she may expose herself to legal perjury. But Carrie Roberts, who actually perjured herself on the stand, no repercussions, right? And the court should ensure that before she proceeds, she has appointed counsel. That kind of sounds like a threat. Clearly, her interests are far from synonymous with Mr. Carney. So now we're going to punish you. Now we're punishing you, Lindsey, for helping us. Because without her, this would not be a thing right now. It wouldn't. Let's just keep it a buck here. Finally, the Commonwealth notes that to the extent any disability arises from Miss Gaetani's ANC, Whenever, if at all, the counterclaim against Cosgrove goes before the Middlesex court, it is unlikely to survive a motion to dismiss or for judgment on the pleadings. Its entire basis is an act by a prosecutor in the course of his duties. And whether or not Cosgrove was correct in concluding that providing a copy of the police report, I can't get over the fact that he's referring to himself in third person because it's clear as day that somebody, his granddaughter, I don't know, say, yo, Graham, stop drooling on the keyboard and step aside. I got this. I got to finish this reply for you. Was proper. Rule 14, discovery, no liability should be attached. He's like, don't touch my money. I made a lot of money off this case, right? The defendant's third and final request is perhaps his most brazen. He asked the court to disqualify Cosgrove from an ongoing investigation of Karen Reed and Mr. Carney for conspiracy to commit witness intimidation because, again, it did not work. The 2005 investigation. Oh my god, who is writing this? The 2005 investigation. You can't even get your facts right, bro. How do people read this with a straight face? I'll never know. To facilitate his demand that his court preemptively intrude on the lawful authority of the executive branch, Carney attempts to mount an attack on a search warrant authorizing seizure of cell phones belonging to Karen Reed. This is all, it's like all roads lead back to Karen Reed. Like they just want to lock him up, and that's it. That's literally it. They don't give a duck about anything else. They don't care, right? Aidan Carney's been reporting and exposing people. A lot of high profile people too. And not a single one of them has gone to this extent or this length and tried to put him in jail. As this court undoubtedly knows, when there is a claim that seized electronic devices may contain attorney-client privilege material, a taint team is generally required. See, generally preventive, blah, 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 blah. Moreover, 2 search warrants are required, though the 2 may effectively be combined into one. Well, I mean, that office has a awfully difficult time in creating affidavits. In fact, if you're Chip Proctor, I mean, he's no longer part of that office, but sometimes you might only turn in half a affidavit, right? And 6 search warrants might just reveal themselves, like 3 years after the fact. So the process is search warrant number 1, authorizing seizure of the device. Taint team established. Search warrant 2, limiting the scope of the search. Presently, the matter of the Karen Reed search warrants and the establishment of a taint team is before this court. Krupp J, having heard argument, received memoranda and taken the matter under advisement, right? So we wait with bated breath to see what happens there on that. It is part of the normal search warrant process. Nothing about any of this and any of your processes and procedures are normal when it has to do with Karen and Turtleboy. None of it. Assuming the court allows the Commonwealth's motion to set up a taint team procedure, and assuming search warrant number 2 is authorized by the court, and assuming a resultant search yields evidence, and assuming, God, like there's alliteration and then there's just repetition that's unnecessary. That evidence results in a grand jury presentation, and assuming that grand jury then indicts Karen Reed, then Karen Reed, as in any other case, may bring a motion to suppress that evidence. Karen Reed may bring such a motion. And again, like what her team does and what his team does, that's a separate thing, but not Carney, who has no stand, as he lacks any possessory or other cognizable legal interest in Karen Reed's phones. Because why would he? He reported the story, created this massive movement. We freed Karen Reed. Why the duck would he care at this point? He cares about freeing himself at this point. The story's out there. The articles are printed. People know. People know the truth. The House defendants have a billboard. What else do you want? It's right outside your door, now falsified. Signed, sealed, delivered by Cosgrove, but he refers to himself as Cosgrove, like halfway through this. So I don't know who wrote this, ChatGPT. I don't think so. Thered be more hyphens if it was, but I definitely think somebody grubby and meatbally had their little fingers in this pie. So And that's the thing that takes me out the most, is the fact that he's referring to himself in the third person. But the sheer audacity, and the fact that you waited all this time to file this motion the morning of. Like, what are people supposed to think? You're completely sidelining and disrespecting counsel, taking a hot, steamy poop on Aiden Carney's rights to a speedy trial, which appear to be non-existent, because looks like now we're looking at end of Scorpio season, beginning of Sagittarius season. The only other creatures on this planet who share the same level of sheer audacity are Florida men eating other men and Tom Sandoval. So, congratulations, Uncle Grandpa. You have now joined their ranks. I hope you're proud of yourself. But with that being said, if you enjoyed today's content, hit that subscribe button, hit that notification bell so you don't miss the next video from me. Make sure you hit that like button, because that tells the YouTube algorithm that this is newsworthy news. And as always, thank you so much for watching, and until next time.
Does that work for you, Attorney Cosgrove?
No, I'm out of the country on all of those dates.